Good afternoon, everybody, and welcome to the second half of our two-part webinar series, which provides an update on key developments in law and policy which will affect the construction industry in 2019. Our webinars will provide an understanding of the key developments in construction and adjudication practice and how these might affect your construction project disputes. This second webinar will focus on prescription and time bar, reviewing the cases of David T. Morrison against ICL Plastics, Gordon Trustees against Campbell, Riddell, Paterson, or CRBP for short, and Midlothian Council against Bracewell Stirling Architects and Others, and all their impact on the construction industry. It will also examine whether the Prescription Scotland Act 2018 is set to adequately clarify the law on prescription in Scotland at the moment. Before we begin, there are just a couple of housekeeping matters to address. To minimise the background noise, I've placed you all on mute. If you'd like to ask questions during the webinar, please do so using the webinar chat function. In order to keep within the 30 minutes, we will be answering as many questions as we can at the end of the presentation, rather than as we go along. So, I am Lee Hurd, a solicitor in the Commercial Disputes team, specialising in construction and engineering dispute resolution and based in Edinburgh. I am joined today by my colleague Lisa Ambrose, a trainee solicitor in our team. We regularly advise on a range of projects and claims, which often require strategic and commercial thinking, formed from our up-to-date understanding of the legislative and industrial context. This experience forms the basis of our advice to our clients and what we will share with you today. I will now pass you on to Lisa, who will run through the agenda for today's webinar.
Thanks, Lee. We will start today by giving a brief outline of prescription law in Scotland as it currently stands. We will look at the legislative position and then we'll discuss the 2014 Supreme Court case of Morrison against ICL, in which the question of when the prescriptive clock starts to run was addressed in the context of an action for damages by the owners of a shop when a plastics factory exploded in Glasgow. We will then discuss Gordon's Trustees against Campbell, Riddell, Paterson LLP, in which the Supreme Court applied the decision in Morrison against ICL to a claim for breach of contract against a firm of solicitors. Next, we will come on to the recent case of Midlothian Council against Bracewell Stirling Architects and Others, which again followed Morrison and Gordon's Trustees in the context of defective gas works found at a housing development which had to be demolished. Finally, we will look at the Prescription Scotland Act 2018, which received royal assent on the 18th of December 2018, which is not yet in force. The 2018 Act intends to clarify at what point the prescriptive period starts to run and addresses various other issues with the law of prescription in Scotland which have been identified over the last 30 years. As some of you may be aware, negative prescription is the rule in Scots law which extinguishes a party's rights and obligations after a certain period of time, meaning that they no longer have particular rights and obligations and therefore cannot take any dispute to court or conversely be taken to court. Different kinds of rights and obligations have different time periods, and these are set out in the Prescription and Limitations Scotland Act 1973. Prescription can also be positive in that rights and obligations are created after a period of time. However, we will be focusing on negative prescription for the purpose of today's webinar. Under the 1973 Act, there is a list of obligations which prescribe or run out after 5 years, and this includes obligations arising from liability to make reparation for loss, injury or damage. This is what most people mean when mentioning prescription in Scots law. However, under Section 11.3 of the 1973 Act, this 5-year time period does not start to run until the party who has suffered the loss is aware, or could have with reasonable diligence been aware, that the loss, injury or damage had occurred. Further, all obligations are subject to a 20-year negative prescription, aside from a few exceptions, regardless of whether or not the relevant party was aware of the loss. This awareness of the loss or damage has been the subject of litigation over the last 5 years, and the topic has grown ever more controversial. It all started with the case of David T. Morrison and Co. Limited against ICL Plastics Limited. On the 11th of May 2004, there was an explosion at ICL's factory in Maryhill in Glasgow. 9 people were killed and many others were injured. Extensive damage was caused to neighbouring properties, including a shop owned by Morrison. On the 13th of August 2009, 5 years and 3 months after the explosion, Morrison raised proceedings seeking damages against ICL for the damage caused to their shop. ICL argued that the claim had prescribed. Morrison's position was that the 5-year prescriptive period did not start running until long after the explosion occurred, since it was not aware, and could not with reasonable diligence have been aware, that the damage had been caused by the negligence, nuisance or breach of statutory duty by ICL until a much later date. This case went all the way up to the Supreme Court. The Supreme Court found in favour of ICL. In interpreting Section 11.3 of the 1973 Act, the Court said that this section did not postpone the prescriptive period until Morrison was aware that the loss had occurred as a result of ICL's breach of duty. Instead, the period commenced when Morrison was aware that it had suffered a loss. This was because, technically, you could not be aware that the damage was a result of the breach of duty until it was decided for definite by the courts. And in any event, if it came down to the pursuer's awareness of the law, the period would run from a different point for different pursuers, which would be an unsatisfactory position. Therefore, the prescriptive clock had started to run in May 2004, when the explosion took place, and the claim had prescribed. This case overturned what was thought to be the established position of prescription in Scotland, in that the pursuer must be aware, or could reasonably be expected to have been aware, that the loss or damage was caused due to the action of another. Morrison did not know that the damage had been caused by the breach of duty by ICL until much later. However, the court held that this was irrelevant. Lord Hodge did note the disruption that this was likely to cause pursuers, and that the law should be reformed.
So following Morrison versus ICL 3 years later, we have the case being applied in the case of Gordon's Trustees against Campbell, Riddell, Paterson, or CRBP. In 2004, CRBP, a firm of solicitors, served notices to quit on behalf of Gordon's Trustees in an attempt to regain possession of 3 areas of land from a tenant. The tenant refused to remove from the land in 2005, and in 2008 the notices to quit were held to be ineffective in relation to 2 of the 3 areas of land. In 2012, Gordon Trustees raised proceedings against the firm of solicitors. At this point, it had only been 4 years since they discovered that the notices were defective. However, it had been 7 years since the tenant had refused to give up possession of the land. This case, like the Morrison case, also made its way up to the Supreme Court and said that for the prescriptive period to start running, the pursuer need only be aware that it suffered a loss and not what actually caused the loss. It went on to note that in relation to the loss, it is not necessary for the pursuer to be aware that something has gone awry. This means that any expenditure incurred by the pursuer as a result of the defender's actions will start the 5-year period for time bar purposes. In saying this, the court provided an example. A person may begin a legal action and incur expenditure on legal fees on the basis of negligent legal advice, or he or she may purchase a house at an overvalue as a result of the negligent advice of a surveyor. In each case, the person may be aware of the expenditure, but not that it necessarily entails the loss. The court said that in both cases, the prescriptive period begins when the expenditure is occurred. This means that in some cases, a right of action can prescribe, arguably, before a party is even aware that the right of action exists at all. In this case, the court said that the prescriptive period started to run from the point in 2005 when the tenants refused to move from the land, and since the action against the solicitors was not raised until 2012, the claim had then prescribed. This is despite the fact that in 2005, Gordon's trustees actually had no knowledge that the notices were defective. Again, the court recognised that this approach can be harsh towards pursuers, where they are aware that they have incurred expenditure, but not aware this expenditure amounts to loss. However, the Supreme Court felt that the alternative was too uncertain, and that in any event, the First Minister had announced reform of the law of prescription. Many commentators found this to be an unsatisfactory position for the judges to take. It had been recognised in Morrison versus ICL 3 years prior to this case that the law needed to change. But as often the case with legislative reform, this is not a speedy process. Meantime, countless pursuers are no doubt feeling the effects of the interpretation of the existing 1973 Act, leaving many without a right of action.
So how does this apply to construction? Well, the recent case of Midlothian Council against Bracewell Stirling Architects and others put the law of prescription to the test in the context of a construction dispute. This case related to a new social housing development in Gore Bridge in Midlothian, which was constructed between 2007 and 2009. This followed advice given by the fourth defenders, Blythe and Blythe, between 2004 and 2006. Tenants moved into the development in 2009, but on the 7th of September 2013, one of the tenants fell ill, and gas was discovered in some of the houses. The tenants all had to be evacuated, and in discovering that the development was constructed without a ground gas defence system, despite being built over a disused mine, the entire development had to be demolished. The council raised a claim for damages for around £12 million against, firstly, the lead consultant, secondly, the contractors who carried out the ground investigations, thirdly, the contractors who had been appointed to peer review the second defender's reports, and fourthly, the consulting engineers, Blythe and Blythe. The fourth defender was brought into the claim on the 4th of September 2018, which was just within 5 years of the tenant falling ill. The council argued that Blythe and Blythe should have advised the council to install a ground gas defence system, and that their failure to do so caused the loss. Blythe and Blythe argued that the claim against them was time-barred, the 5-year period having expired prior to the council becoming aware of the problem in September 2013, when the tenant fell ill, and this was relying on Morrison against ICL and the Gordon's trustees. Blythe and Blythe said that the loss suffered by the council was the expenditure which they had incurred constructing the development, and at the latest, the prescriptive period had started to run from practical completion of the development in 2009. The council argued that their damages claim was not based on the recovery of the costs of construction of the development, but on the cost of demolishing and rebuilding the development, which had not been incurred until 2015. The court again applied Morrison against ICL and Gordon's trustees, and held that the action had prescribed. Lord Docherty accepted that the council had been unaware until 2013 that there was a problem with the development. However, following Gordon's trustees, this did not mean that they were unaware that they had suffered loss, injury or damage in terms of the 1973 Act. Lord Docherty also noted in his decision that when the Prescription Scotland Act 2018 comes into force, this will affect substantial amendments to the law. However, he noted that this case had to be decided on the basis of the current law. This case has huge ramifications for the construction industry. More often than not, defects in large projects do not show themselves until several years down the line, at which point it can be more than 5 years since the cost of the project was incurred. This means that the prescriptive period can run out before a pursuer even knew that there was a claim. This seems grossly unfair and has understandably caused widespread concern across the industry. Although in his judgment, Lord Docherty again referred to the substantial amendments due to be effected to the law of prescription in Scotland, of course it is still not clear when these amendments will come into force. This case is a prime example of how the court's current interpretation of the 1973 Act can have an adverse impact on pursuers in construction disputes. Although the housing development was completed in 2009, the council were not aware that there was a problem with the ground gas defence system until one of the tenants fell ill in 2013. However, the court held that the prescriptive clock started to run from the completion of the development in 2009. Although it is not expressed in the judgment, it may actually have started to run when the design work was paid for in 2007, meaning the claim had prescribed before the council even knew it was a claim. This is despite the fact that Midlothian had no way of knowing that this expenditure amounted to a loss, or whether this loss was attributable to the negligence, nuisance, or breach of statutory duty of the defenders, and indeed, which defender. It is extremely common in construction projects for defects not to show themselves until a number of years later. If this takes 5 years, the cases of Morrison, Gordon's Trustees and Midlothian Council all lend themselves to the conclusion that no action could be raised at all. This is clearly unsatisfactory. Another factor to take into account is that often collateral warranties contain standard wording that the party giving the collateral warranty accepts liability for 12 years and not 5. As per Section 13 of the 1973 Act, any provision in an agreement purporting to contract out of the 5-year prescriptive period is ineffective. In this clear inconsistency, the Act takes precedence, meaning the maximum period in which you could make a claim on the basis of the collateral warranty would be 5 years. Another nuance of construction law in relation to prescription is adjudication. Although commencing arbitration proceedings has been held to interrupt the prescriptive period, adjudication has not. Adjudication is of course widely used to resolve disputes in construction, so arguably this could cause some concern. However, the nature of adjudication is that it is fast, rough justice and can resolve disputes quickly during the running of the contract, when arguably prescription should not be such an issue. For larger disputes which arise further down the line after the contract is ended, court actions or arbitration would arguably be more appropriate.
Thank you, Lisa. That brings us now neatly on to the Prescription Scotland Act 2018. So the Act was first introduced as a bill in February 2018 and received royal assent on the 18th of December. It seeks to reform the law of negative prescription in Scotland, particularly in terms of the issues which have caused difficulty in practice and which we have touched upon today. It aims to increase clarity, certainty and fairness, and also promote a more efficient use of resources. The Act is not yet in force. Interestingly, at consultation stage, it was explored whether there should be a separate rule for construction contracts in relation to the long stop of 20-year prescription. This was because it had been suggested in the past that the prescription period should start to run from the date of practical completion of construction works, rather than just from when the obligation becomes enforceable. However, it was decided to promote certainty, and because construction contracts often have extensive provisions in relation to the sharing of risk, that there should not be a separate regime for 20-year prescription in construction contracts. So the 2018 makes a number of changes to the existing 1973 Act. Firstly, it clarifies that neither the 5-year nor the 20-year prescriptive periods apply when another statutory enactment specifies a different time limit or makes an obligation imprescribable. Secondly, it attempts to simplify the list of obligations to which the 5-year prescription period applies. Thirdly, it introduces further exceptions to the 5-year prescription rule. Fourthly, it changes the title of the section Obligations to Make Reparation to Obligations to Pay Damages, in an attempt to avoid any future confusion. Fifthly, it includes provisions whereby the 20-year period cannot be interrupted by either a relevant claim or, in the case of Section 7, relevant acknowledgement in the period. However, it can be extended in particular circumstances. The sixth point is that it seeks to address the question of who bears the burden of proof of prescription. And finally, point 7, it allows for standstill agreements to be entered into in certain circumstances, whereby parties can agree to extend the 5-year prescription period for only 1 additional year to avoid unnecessary court actions being raised, and as those of you who have been involved in them, often in a hurry, to avoid the effect of time bar and prescription. The raising such actions is costly and can often break down negotiations. However, by far the most anticipated change, and the topic of today's webinar, is the change to Section 11.3 of the 1973 Act, which is basically the test as to when the pursuer became aware of the loss, injury, or damage. The 2018 Act will make changes to this test as a result of the decision in Morrison against ICL and the decisions which followed it, so that it is now clear in Scotland that the pursuer must have knowledge of the loss before the prescriptive period starts to run. In particular, the pursuer must be aware, or with reasonable diligence could be aware, that 1, the loss, injury or damage has occurred, 2, that the loss, injury or damage was caused by a person's act or omission, and thirdly, the identity of that person. So, with this amendment, the pursuer is then no longer prejudiced by the 5-year prescriptive period starting to run without having actual knowledge that they suffered a loss. Had this section been in force at the time of the 3 cases we've discussed today in this webinar, arguably none of them would have been time barred. In effect, these changes will return the law to what was thought to be the position prior to the Morrison and ICL case. For pursuers, this is undoubtedly a positive change in the law, and more certainty can only be a good thing. The intention of the law of prescription is to ensure that claims are not held over the heads of defenders forever, and to promote certainty and discourage delay. The idea is that it's fairer to deprive one person of a right rather than to allow it to trouble another. However, the concepts of loss and awareness are still quite abstract, and perhaps their interpretation is open for debate, meaning the question of whether the pursuer was aware of the loss becomes less objective and more subjective. As we mentioned before, the Act is still not in force, so it's unclear when it will become actual law in Scotland. Therefore, for the moment, pursuers will continue to fall foul of the current law on prescription until such time as the Act is introduced, given that the courts have continued to apply the law strictly following the cases discussed today, with harsh results on the part of the pursuers. So, what can we take away from today as a lessons learned? Well, in the construction industry, where some projects take a long time to be constructed and where defects can often not show themselves for a number of years, prescription must be the first consideration to be taken into account when considering whether or not to raise a court action or commence arbitration proceedings. The consequences of a court action being knocked out due to prescription are of course drastic, and so legal advice should be sought at the earliest opportunity when a potential claim arises. Given that the law on prescription has not yet been reformed, we would urge potential pursuers to act as quickly as possible if you're aware of any cases which may be borderline, and to err on the side of caution when calculating the date from when the prescriptive clock starts to run. Finally, as we mentioned earlier, we do not know yet when the 2018 Act will come into force, so meantime it appears that the prescriptive period can start to run from the point of first incurring expenditure on a construction contract, and often the case in construction contracts, 5 years is not a lot of time to take action. Because of all this, we would urge you to try and keep up to date with legislative developments and listening to our future webinars to be aware of when the law changes. We also do not know for sure whether the 2018 Act will address the concerns expressed about prescription law in Scotland, or how it will work in practice until it actually comes into force and is interpreted by the courts. Therefore, we'll be keeping a close eye on the introduction of the Act and thereafter on the first few cases to hit the courts after it comes into force.
So we have now come to the end of this webinar, which we hope has been useful and interesting, and we still have a few minutes left to answer any questions. If you haven't already done so, please type your questions into the chat box now. Whilst you're doing that, I would just like to take the opportunity to remind you that this is the second webinar in a two-part series, and that both of the webinars from this series have been recorded and will be available on our YouTube channel and Vimeo site, if you would like to listen again or share with colleagues. We will also be running an autumn webinar series and autumn in-person seminars, so please do keep an eye out on your emails and on our website to please sign up to those. We are also delighted to announce that we will soon be launching our S&W construction update, which will keep everyone up to date on case law, legislative updates and construction industry trends in between our webinars. If you would like to be added to our mailing list for this update, please drop one of our team an email, and also keep an eye on our website over the next few weeks.
Thank you, Lisa. So we do have one question which relates to how does all this sit if you have an English court action. Well, as many of you will probably be aware, the English law in relation to limitation is different from Scotland. In Scotland, we have prescription, which is where an obligation is extinguished and no longer exists. And in England, you have limitation, where your obligation still exists, but you're limited from bringing a court action in relation to it. The time periods are also different. In England, the most common ones being 6 years and 12 years, depending on whether or not your document's executed as a deed, and there's also a few other differences. What we would say is that we do actually have a useful article on our website comparing the law of prescription as it stands at the moment under the 1973 Act with the English legislation. So I would definitely direct you to that. And also we'll be doing an update on that article once the 2018 Act comes into force. We just got another question in there, second question, about latent defect insurance has been taken out and whether these changes will lead to a rise in it being taken out. I think our comment in relation to that will be that if that's a risk, especially with a longer project at the moment, I would see more that the recent case law will probably mean there has been a spike in that, or it's something that should be being considered. But hopefully once you've got this reform from the 2018 Act, that will hopefully start sorting that out. However, as we've been saying in the webinar, if in doubt, seek legal advice, get claims notified and actions raised as early as possible to avoid being without a claim. Okay, well, that's the last of our questions and our time's up for today. If you have any other questions after the webinar, feel free to drop us an email and we can come back to you. I do hope you've all enjoyed our webinar and found it informative and useful, and we look forward to welcoming you to future webinars and seminars. Thank you.